We will call our last case of the October call, Dine Brands Global versus Eubanks. It is officially afternoon, so good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone that you may waive, and Mr. Ziemer, you have the option to reserve rebuttal time, but we ask that you do your best to keep track of that. You may begin when you're ready.
Good afternoon. May it please the court, my name is James Allen Ziemer, and I'm appearing today on behalf of the State Treasurer, Rachael Eubanks. With me at council table is our Solicitor General, Ann Sherman. I'm going to attempt to reserve 3 minutes of my time for rebuttal. The purpose of the Unclaimed Property Act is to minimize litigation with other states, with holders, and with owners. In Michigan, it replaces a lawsuit seeking judicial abandonment with statutory abandonment, and it replaces a bill of discovery with an administrative examination. Rather than having all the states race and compete with each other for the exact same property, the Unclaimed Property Act creates a mechanism for those states to work together and resolve their disputes in a single multi-state audit. Because of the Court of Appeals' published decision, Michigan and its residents are losing out. And just to be clear, filing a lawsuit and filing the statutory process laid out in the Act are two separate pathways. Now, we agree with the Court of Appeals' unpublished decision issued on remand regarding the second and third questions presented by this court. Regarding the first question, what is an action or proceeding? That unpublished decision demonstrates the harmony that's created in the Act by simply interpreting the word proceeding to include the examination. Now, the word proceeding is a broad term, the carrying on of a course of action, but it cannot be read in a vacuum. And in the context of the Unclaimed Property Act, it's referring to an administrative proceeding, a formal investigation into the property, its ownership, and its abandonment. It's quasi-judicial in nature, and it is subject to appeal. By design, this is the only detailed statutory process set forth in the Act for enforcement, and the Court of Appeals' published decision negates it. I see that I'm out of time. Turning just to the legislative history for a moment, Michigan's escheatment process was entirely judicial. It was done by the courts. The state public administrator under the Code of Escheats would have to go to court, file a lawsuit, notice of owners, any interested parties, and seek judicial abandonment to formally transfer title to the state to effectuate the escheatment. There was no statute of limitations, and if they wanted to examine records, they would seek a bill of discovery. That was an inefficient use of the court's time and resources. The Unclaimed Property Act takes that judicial process and makes it entirely administrative. And to do so, it vested the treasurer with the administrative authority to administer and enforce the act. If the legislature intended Michigan to continue to file lawsuits in this subject area, it would have said so, or it would have retained some of the provisions from the Code of Escheats. It did not. The second takeaway from that, and looking at the Act and how it operates in generally, a lawsuit filed by the state is not a step in the regulatory process. Rather, it is an overarching authority to enforce compliance with that process itself.
So am I correct? You need, in order for your position to win, you need us, even if we were to agree with you that an examination is a proceeding, you need also for us to say that the initiation of the examination tolls the time to bring in an action then.
No, Your Honor.
You don't. We don't need to say that.
No, and this goes to the Court of Appeals unpublished decision issued on remand from this court. The examination concludes with a formal administrative decision. So any lawsuit that the treasurer would file would be to enforce that final administrative decision, which the claim accrual would begin to accrue once the date that decision is issued. So tolling would not be an issue really at all.
Well, you're then construing, I mean, because the statute says that an action or proceeding shall not be commenced by the administrator within 10 years of after the duty arose. So you're saying it's not the initial duty of the holder to disclose and turn over the information. It's the duty to comply with the decision from the examination.
Correct, Your Honor. And the final administrative decision, the examination determination, also includes a written demand for the turnover of the property.
Are those really any different? I mean, I get that they're happen at different times and they're called different things, but if the result of determination from the examination says, yes, this is what you owe, didn't the holder owe it back before you even started the examination? Is there really a distinction in the duty? Why isn't it that duty, why isn't that 10-year statute of limitations govern? Maybe yes, an examination is a proceeding, and so that has to be initiated with 10 years. Why does the action, if an administrator files it, not also have to file 10 years from that original date?
And to clarify and address your question head on, it is a crime to fail to comply with that written demand.
So that is
a duty.
different than the initial?
Correct.
Okay.
And just turning to the administrative rules and how this process works, and it is uniform throughout the states. In Michigan, examinations are formally commenced by administrative rule with a notice of commencement. So there is a date certain, there is a document that formally commences it.
Is there a time restraint on that, on when those need to be completed?
On when the examination needs to be completed? No.
Okay.
There is no time complaint or restraint, Your Honor. And there are 2 points to make on that. One, by administrative rule as well, the parties are required to work in good faith with one another. And the second, it's heavily reliant on the holder producing documentation. So however long it takes the holder to produce the records is how long it's going to take to complete the examination. In a nutshell and just big picture, in the escheatment process, we're talking about properties that don't belong to the holder anyway. We're just trying to remove them from the property so that the states can figure out where it escheats and try to return that property back to its owner.
So how long after the examination determination do you have to file, to commence a lawsuit?
To file a lawsuit?
Yeah.
So it would be 10 years, where our position is that it would be that same 10-year period. I would just note a couple things. One, the statutory scheme places the burden on the holder to challenge that administrative decision, so we could be tied up in litigation there. Two, we've never had to wait that long. That situation's never arisen where we're running up to the end of a statute of limitations to file a lawsuit.
Okay.
So in theory, I mean, you could have the obligation arises in year one, you wait until just before year 10 to initiate an examination. That examination can take, as you said, however long it needs to take, which could be a lengthy period of time, right, as evidenced by some of this.
Correct.
And then you get an additional 10 years on the end of that?
That is the way the statute,
Okay.
that is the only statute of limitations period contained in the Act. And just to flesh that out kind of in process. On the front end, the treasurer is tasked with administering and enforcing the Act. And there are record retention requirements for 10 years. And the only way to see if that's been complied with is to look 10 years back. The second, on the back end, and just fleshing this out, in the event, and this does happen, a holder files for Chapter 11 bankruptcy right after we issue the administrative decision. That proceeding, that bankruptcy is occurring and eating up the clock. And there is an automatic stay in place preventing us from going outside of the bankruptcy proceeding absent filing for relief within the bankruptcy court. So that clock hypothetically can be eaten up quite a bit by
It's not
other
subject to the
circumstances.
automatic stay for the bankruptcy?
We would, it would be subject to the automatic stay, absent petitioning the bankruptcy court for relief from that stay.
So how does it eat up time? Sorry.
Yeah. Yeah, that's
Well, the
my
bankruptcy
question.
proceeding itself is going to eat up time, so as long as that automatic stays in place, we cannot proceed to
Right,
try
but
to
if
take any
it's
sort of
stayed,
collection.
if
But it's not
been
eating up the
initiated, it's
10-year
not eating up
period.
your time.
It's just delaying.
If the administrative decision's already been issued, now we're on the clock to file the lawsuit. And if the bankruptcy proceeding's occurring in the interim period, it's eating up that time.
It wouldn't stay your
So the
time.
tolling provisions in bankruptcy code is typically 6 months after, it extends it 6 months after the bankruptcy proceeding closes.
Is a bankruptcy always an incident or just
It-
frequently, or even frequently?
It does arise, it's infrequent, and it just generally, litigation with holders generally is rare nationwide. We don't really, nationwide, there's rarely disputes with holders because it's not their property. And this goes to the nature of an unclaimed property examination. Our records, the state's evidence, is the holder's records. Our information is what their information says. So there's rarely a dispute. There's not much to argue about whether this property belongs to somebody else.
And is this sort of an academic exercise in any event, because this case isn't an action initiated by the administrator anyway?
I apologize, Your Honor.
I mean, this was initiated by the holder, right?
This case?
These cases?
Yes.
So
Under-
whether or not the statute of limitations that might apply to an administrator's action.
Correct.
may
So
not
under the
actually be an
court,
issue here.
under the Court of Appeals published decision, the clock's still running on our time. So we would, under the Court of Appeals published decision, we're completely out from taking any action on this. And this ties into the uniformity, and I wanted to address this briefly. These were all multi-state examinations, and based upon information and belief. Every other state that participated has either been paid or is in the process of being paid. We're the only outliers, and these are the
Yeah, so
only
you
lawsuits.
started with that point. Explain that a little bit further, of why Michigan is an outlier there.
Sure. So these are administrative acts, and they're just,
Are the other states doing something different?
no. Well, the other states operated exactly the same way Michigan operated prior to the published Court of Appeals decision. So each state starts with the commencement of an examination, administers it, issues findings, and that's it. And just to highlight why a lawsuit's not there on the back end, that leads us right back into judicial abandonment, which is what the Act's designed not to do. The Act's designed to be statutory abandonment, just a presumption of abandonment, again, trying to minimize litigation. To the extent an owner wants to later come back and contest the abandonment, they can. But generally they don't, because the goal of the Unclaimed Property Act is already to get that property back to them. So, again, it's an administrative act. We're trying to cut out and reduce litigation. I know that sounds weird having an attorney say that, but that's the point. And so it's not a step in the process by design. States aren't filing lawsuits as an ordinary routine part of the process after examinations.
Okay.
We know some states obviously have been a little more specific on the statute of limitations and tolling and whatnot. And I know our statute is not exactly the same as others. So are there states that have, I guess, have language the same as ours, that have interpreted their statute the same as you're saying we should interpret it?
Sure, so each state's its own sovereign, and what I would say to this, there are textual nuances between the varying states, but the important takeaway here is all the states operate and administer their unclaimed property acts identically, which is it's an administrative enforcement action. It's an examination. They vest their treasurer or their comptroller, whoever they're putting in charge, whether it be a body or an individual, to enforce the act administratively and take that action, or enforce it without resorting to the court. That's in a nutshell, that's the point of how the acts operate uniformly. I see I'm running low on time. I'd like to reserve the balance for rebuttal.
Thank you.
Thank you.
May it please the court, Ethan Millar for Appellee's, the Walt Disney Company and Dine brands. So good afternoon, Justices. So the question in this case is, as you all know, is whether the treasurer is time barred from escheating certain disputed items. These are mainly voided checks that were issued by Disney and Dine brands as far back as 2002. The statute of limitations here is very generous, 10 years for most types of property, 5 years for obligations due to another business. That's longer already than almost every other statute of limitations under Michigan law. But as you heard from Treasurer's Counsel, that's still not enough time for them. At least that's what they argue. They want an unlimited amount of time to conduct an examination and then file claims against the holder of unclaimed property or putative holder of unclaimed property. The circuit court in this case, in a unanimous Court of Appeals, rejected the treasurer's arguments here. Treasurer appealed, and this court has asked the parties to address 3 questions. So turning to the first question that this court asked is whether the Court of Appeals erred in holding that an action or proceeding does not include an examination. The court did not err. The court conducted an exhaustive review of the provisions of the Unclaimed Property Act and correctly, in our view, determined that every time that the terms action and proceeding are used in the statute, they're referring to judicial dispute resolution processes. An examination is just a records review. It's not even a quasi-judicial or administrative dispute resolution process. There's no hearing. There's
Counsel,
no,
can you help me out then? What would a proceeding be? I mean, I understand the argument that we think of a proceeding as some formal something, but
Yes.
what would it be then under the statute?
Yes, it's a good question. So, as you know, the Unclaimed Property Act really has one enforcement provision. That's MCL 567253, which says that the treasurer can initiate an action in court to enforce the Unclaimed Property Act. The statute of limitations then says that the treasurer shall not commence any action or proceeding after the 10-year period. So the Michigan Uniform Unclaimed Property Act is based on the Uniform Unclaimed Property Act of 1981, and the statute of limitations in both acts is identical. And so we look to the commentary of that Uniform Act to identify what the legislative intent here was. This court has recognized that where the Michigan statute is based on a model act like this one, then it's appropriate to consider the official comments to that act as evidence of the legislature's intent and meaning here. And so in the commentary, the drafters made clear that what they're really concerned about is lawsuits. They said that the purpose of the statute of limitations is to prevent the holder from being subject to suit after an indefinite period of time. They wanted a strict cutoff date that the holder could rely on, that the holder would be comfortable that they're not going to be subject to claims under the Unclaimed Property Act.
So I totally understand that.
Right.
Then is proceeding they just paraphrased action, action? They just were saying the same thing over?
I think they were trying to be thorough, to be honest. I think that they could have said action, but I think the drafters were trying to be thorough here, and they thought, well, we want to make sure that the treasurer can't take any action, or make any sort of claim against the holder after that 10-year period And so proceeding has been construed in other contexts in some of this court's decisions, like in the Myers v. Barlock case, to be broader and to encompass, other judicial processes. And so I think the intent was really as sort of a catch-all, that to the extent that there's some kind of a claim that the treasurer could have made that doesn't meet the definition of action, then proceeding would qualify. And when you look at the other instances in which the terms action or proceeding was used in the Unclaimed Property Act, the same sort of, I think, intent applies, right? Because the act prohibits owners, for instance, of initiating certain actions or proceedings against the treasurer or against the holder of unclaimed property, when their property is disposed of pursuant to the act. And so again, I think it was really intended to just be a very broad kind of covering any sort of judicial enforcement mechanism.
Okay, so next question.
Yes.
So the statute talks about that, no action or proceeding can be brought, more than 10 years after, with respect to any duty of the holder. And I know your argument is the duty at issue is the original notice to report.
Correct.
Or reporting obligation. But it says any duty, and aren't there multiple duties under this statute?
Yes, and so again, I would refer back to, again, the commentary to the Uniform Act, which addressed that exact point as well. So Treasurer's Counsel argues that the statute of limitations is somehow reset based on some kind of a future duty. In that case, again, it would defeat the whole purpose of giving the treasurer a clear cutoff date on which it can rely, after which it will not be subject to claim. But also the language of the commentary is explicit here. It says the administrator must commence an action against the holder within 10 years, quote, after the time the property was first reportable. And again, that's a very clear, explicit cutoff date. And so any holder, whether it's a big company like Disney or Dine Brands, or a small restaurant company that could also hold unclaimed property, it has a definite period of time that it knows after which it's protected by the statute of limitations from any kind of claim. I'd also add
does
that,
a holder have a duty to comply with a determination following an examination?
well, the holder has an option based on MCL 567251A, which was adopted in 2015 after these audits were commenced. But, and under that statute, the holder has the option of either appealing administratively or initiating an action against the treasurer. If the holder...
They have things they can do with it, but do they have a duty to comply with the determination?
If the determination, if the treasurer would have to file an action to enforce that determination against the holder. The state has the burden of proof here, right? So that's the Willsmore v. Osceola case in Michigan. Remember, the state is standing in the shoes of the creditor here, or putative creditor. You know, these could be other businesses or, you know, employees or customers or someone who didn't cash their check for whatever reason. The state is acting as a custodian on behalf of these people, you know, who are absent, right? But the question in these audits is whether these voided checks are actually owed to people, right? And so the treasurer is making a determination in the audit, you know, what they think the is property that's owed to other parties, but the holder or putative holder has the right to dispute that, and if the holder doesn't exercise its appeal rights, the treasurer would still have to file an enforcement action against the holder. There's nothing in MCL 567251A that provides that either the holder waives any rights or defenses by not appealing. There's nothing in that statute that alters the statutory framework that would change the statute of limitations or change the enforcement process. under the Act. Certainly, if the treasurer proves its claims in the audit, through a subsequent enforcement action, then of course the holder is bound by that determination. So, kind of getting back to the three issues that the court wanted us to address in this case. So, the first question again is sort of this action or proceeding question. We already talked about how those terms are used in the statute, and the fact that the court itself has recognized that proceeding generally means a judicial process, or at the minimum a quasi-judicial or administrative process, which an audit would not qualify for, because there is no hearing, there is no ability to conduct discovery or anything of that nature. We talked about the commentary to the Act. I would also point this court again to a couple of other states that looked at identical provisions to this Act. One is in Delaware. We cited in our papers that Delaware has adopted a statute of limitations identical to Michigan, but then they added in that phrase in the statute that the statute is told upon the commencement of an examination. So obviously the legislature there was interpreting this statute the same way as Disney and Dine brands. Otherwise, that additional language would have been unnecessary. Next, there's the revised Uniform Unclaimed Property Act. The Unclaimed Property Act was amended in 2016 to change the statute of limitations by adding in the word examination. So now it provides that an action, proceeding, or examination shall not be commenced after the statutory deadline, the 10-year period. And so clearly by adding in that word examination, the drafters are demonstrating that that must mean something different than an action or proceeding. Otherwise, it wouldn't have been necessary to amend the statute in that way. Moving on to the next question regarding tolling, this court has consistently held that tolling does not apply absent express statutory language. There's the Trentadue case that we cited in our papers, as well as the Shabbat-Lutivich case. And so clearly in this case, MCL 567250, the statute of limitations doesn't include any express tolling language, and so we would argue that none should be implied here. The third question, which I think Justice Kavanaugh, you were getting at earlier about, is even if an examination constitutes an action or proceeding, then the next question is whether the treasurer must still file a lawsuit or an action within that 10-year period. The answer is yes, that the statute there is pretty clear, I think, based on the plain language. So again, it says an action or proceeding shall not be commenced after the 10-year statutory period. And there are several cases we cited in our papers, the Pfaffel case, the Patton case, and the Sheboygan case, all of which held where a statute prohibits multiple things and they're separated by the disjunctive or, that means if you do any of those things, it violates the statute. And so that's, I think, a common English, plain English reading of the statute here, that the treasurer shall not commence either an action or a proceeding after the deadline. And so if the treasurer were to commence an action against our clients now, it would be violating the statute. The Court of Appeals, in its November 2023 advisory opinion, I think just misread the statute. I will quote some language from the court's decision. So they say, and I quote, MCL 567250, subparagraph 2, only requires that an action or a proceeding be commenced within the applicable time period. Well, that's completely twisting the statute around. There's a big difference between if the statute says you have to commence an action or proceeding within the 10-year period. Under plain English, that means that you could satisfy the statute by doing either one or the other. It's completely different if the statute prohibits an action or proceeding after the 10-year period. And so we respectfully suggest that the Court of Appeals got that wrong. The commentary again to the Model Act, I think, reinforces our position on that as well. There's also the record retention requirement in the Michigan Unclaimed Property Act. This kind of gets back to the same point, I think, Justice Welch, you were asking about earlier, which is that the record retention requirement states that holders shall be required to maintain certain records regarding owners of unclaimed property for a period of 10 years after the property was required to.
One final question before we wrap up.
Oh, yes.
Under your interpretation,
Yeah.
and I'm going to ask Brother Counsel the same question. Does this have an impact on how the state can continue to participate in multi-state audits, which they're statutorily permitted to do?
Yes, Your Honor. So our interpretation doesn't prohibit the state from participating in these audits.
Not prohibit, does it impact it in any way?
Well, of course, we want the state to conduct examinations efficiently, right, within the 10-year period. States that conduct their own state audits, New York, California, they typically complete audits within 6 to 12 months. Even Michigan states that it should be able to complete its audit within 18 months.
But I'm asking about multi-state.
If it's a multi-state audit, then by definition, it'll likely take a little bit more time, depending on how many states are involved in the audit. But it shouldn't still take an unlimited amount of time, and I think 10 years is still a very generous period of time that contemplates that multiple states might be involved in the examination. There's no reason in our view why the state still can't conduct the examination within that time period and file an enforcement action if necessary.
Thank you very much. Any other
You're welcome.
questions? Okay, thank you.
Thank you.
I'm sure you have some quick points to make, but if you could answer that question first.
So, yeah, just a few points, but to tie into the multi-state examination component first. Because of Michigan's ability to participate in multi-state examinations, Michigan returns approximately $100 million annually to citizens of the state. Requiring us to file a lawsuit is going to take us completely outside the multi-state examination process. That lawsuit is going to be occurring contemporaneous and in competition with the multi-state audit, because the statute of limitations is running against us. If we have to file a lawsuit and we're getting measured on, the time is running on us for when we file a lawsuit in every other state, that time has stopped based upon when they commence the examination, which is all we're asking for. There's going to be a conflict. And again, the nature of this is we're competing for the same property. Intangible property is subject to escheat in more than one state at one time. There are priority rules established by the U.S. Supreme Court. Out of time. If I may, I guess I need to wrap up. We're asking that this court either grant the application or alternatively vacate the Court of Appeals published decision, hold that an examination is a proceeding as the word is used in the act, and adopt the Court of Appeals unpublished decision issued on remand. Thank you.
Thank you both. The case will be submitted and the court is adjourned.